section. There was not much to cover in the IR section because not much has happened in the IR section in the last week. But yes, there are surely some articles that are important from prelims as well as mains perspective in our polity part. So we'll cover the 3 articles from there. First article is related to the victim rehabilitation and the protection plan given by the Supreme Court. Second article is related to the reduction of nomination papers of what we call as Rajya Sabha MP in Madhya Pradesh. And third, we'll also understand the election symbol allocation method in India, and that can Cockroach Janata Party can be given the election symbol of a cockroach or not. So we'll try to understand what are the rules governing the same. The first article that we have to discuss is regarding the process of what we call as for the survivors of trafficking, Supreme Court plan focuses on consent and dignity. Now, Supreme Court has given this plan. The first question that arises into mind that what this article is all about. This article is all about Article 23. Article 23 basically bestows the duty upon the state to prevent any kind of exploitation. And Article 23 is one of the few fundamental rights in our constitution that basically provides the protection against exploitation done by private citizens apart from that of state. So this is important. Now what Supreme Court has done in this case, Supreme Court has linked Article 23 with Article 21, that is not only preventing exploitation but also associating it with dignity. Supreme Court has also used Article 142 and Article 32 in its power to decide upon this case and to do complete justice under Article 142. Thirdly, Supreme Court has also distinguished between prostitution in the sense when someone is being forced into prostitution and someone voluntarily decides to go into prostitution. Though the reason of the voluntary decision to go into prostitution will also be poverty, but then it is a matter of consent, it is a matter of choice. So we will understand all these things one by one. First, let us look at the constitutional provisions under Article 23, what Article 23 talks about. So Article 23 basically talks about prohibition of traffic in human beings and forced labor. And it basically prohibits trafficking in human beings, begar and other forms of forced labor, and makes any contravention punishable offense. It is also one of the rights that is enforceable. I have already told you it is enforceable against private individual and not just against the state. Okay, so we'll understand how it is, what Article 23 is all about. The court read trafficking as a direct assault on constitutional dignity. The court has read in this case that it is a direct assault on constitutional dignity. Then what the court has done, the court has also associated this with Article 21. That is, it has associated Article 23 with Article 21, that is right to life and personal liberty. The bench's most significant move was to locate an enforceable fundamental right to rehabilitation. So what they have done is that they have made rehabilitation as a part of Article 21. Why? Because they are saying that Article 23 and 21 are related because it provides for dignity of the individuals. So rehabilitation is must. The state's obligation to provide the means of rehabilitation does not authorize it to impose a rehabilitative process on victim against her will. But at the same time, they are also saying that the state cannot impose rehabilitation. Why? This was the second thing I was talking about, where the Supreme Court has distinguished between prostitution when someone is being forced. So if someone is being forced, someone is being pushed into prostitution by coercion, they will be rehabilitated by the state. But if someone enters into prostitution for any reason, basically it enters because of the poverty reason, and is voluntarily engaging in prostitution activities, the state will not use the coercive apparatus to rehabilitate her. So this is the difference that the Supreme Court has created. Rehabilitation when someone is being forced into prostitution, and rehabilitation to be a matter of choice of the individual and not on the coercion of part of the state. What is Supreme Court further done? Supreme Court has further utilized Article 32 and Article 142, that is the enabling powers, because the Parliament has not enacted any detailed anti-trafficking rule. So what basically we have to understand that while Article 32 and Article 142 were invoked, it is basically done in order to basically plug in any kind of loopholes that may be there, where there has been loopholes on the Parliament to enact a law in this regard. So this is a classical judicial gap filling that the Supreme Court has done in this case. The Supreme Court also referred to the Immoral Traffic Prevention Act that was passed way back in 1956, and basically says that the Immoral Traffic Prevention Act, which is the principal statute governing commercial sexual exploitation, it does not discriminalize prostitution per se. This act does not criminalize prostitution per se. So prostitution is not criminalized as per this act. But what this act do, it will criminalize the prostitution when it is happening through an organized manner. That is, it is organized exploitation. Someone is soliciting someone to enter into prostitution. Brothels are being run where the people or the victims are being pushed into prostitution against their wishes, and living on the earnings or procuring of the same is also criminalized. So prostitution per se is not criminalized, but if someone is being forced into prostitution, it is organized into an organized crime method, procuring or soliciting or something, that is basically criticized. If someone is soliciting anyone to enter into prostitution. Prostitution per se is not criminalized by this act. Now, what is the Supreme Court further saying? Supreme Court further highlighted section 17 in this act, saying that though these provisions are not very important, but we are understanding it from the holistic perspective, what it is trying to say, that section 17 basically in event of any raid governs what happens after a person is removed from a brothel during a raid. So a raid has happened into a brothel where the victims have been kept. So what this the act was doing, what this Immoral Traffic Prevention Act was doing, that the court flagged that it lumps trafficked victims and voluntary adult sex workers together. So the act was not distinguishes. Some brothel is being raided, now people have been rescued. So the act is not distinguishing between the people who were forced into the prostitution and who were voluntarily doing the prostitution. It used to club them all together and use the same method for their rehabilitation. But the Supreme Court has now said the rehabilitation cannot be forced. If someone has entered into prostitution voluntarily, then he or she has the choice to decide whether they want to continue with the rehabilitation or not. Rehabilitation is there for victims. This is the thing that they have highlighted in the present judgment. Now, what is the basically direction that they have given under the victim protection plan? The victim protection plan is been on the principle of consent. Consent is the dividing line. What it's saying, that consent is determining factor distinguishing a trafficking from voluntary adult sex, and authorities must conduct a preliminary inquiry before taking any coercive action. So preliminary inquiry to identify whether a person has voluntarily entered into prostitution or they have been forced into prostitution. If they have voluntarily entered into prostitution, then whether they want rehabilitation from the part of state or not, it is up to that person. If they have been coercively forced into prostitution, then the state can help them. So rehabilitation is based on the idea of consent. Consent is the dividing line. No criminalization or no forced rehabilitation. There will be no forced rehabilitation, again bringing the consent line, and no criminalization. For example, if the people are being, a brothel has been raided, the people will not be arrested. These people will not be arrested. They will not be photographed in a manner that their identity will be revealed. Again, relating into Article 21, dignity. So what it is saying, let us see. Victims are not to be arrested, subjected to verbal or physical abuse, photographed or filmed in an identity revealing manner. So this has to be done, again relating to the identity part or relating to the dignity part under Article 21. Now, what is the guideline further saying? What is the rehabilitation plan or the victim protection plan against saying of Supreme Court? That it guarantees what we call as services. What services are being guaranteed? Legal aid, counseling, medical care, safe accommodation, livelihood support, and individualized rehabilitation will also be promised to the victims who have been rescued. And it also says that this anti-human trafficking units are to be headed by the officers of that of DSP level and above. They are to be carried out by DSP level and above for registering and probing trafficking cases. Child cases require child-sensitive coordination. So they have also designated in the victim protection plan that who is the officer who will be responsible for this anti-trafficking unit. And lastly, they also have given the dignity reasoning where they have highlighted. So there was another old case that was also seen, which is known as Kamascar case versus State of Bengal. Kamascar versus State of Bengal. It is famously known as Kamascar versus State of Bengal case. In that particular case in 2011, it was said that even if the people are engaged into prostitution, even if someone is engaged into prostitution, they should still be treated with dignity. Dignity cannot be separated even if the people are engaged into prostitution. If anyone has engaged into prostitution because of socio-economic background, this does not mean that Article 21 is not provided to them. So again, the court has reiterated the same dignity lining, and it has associated the same dignity lining, saying that it is up to the victim and up to the voluntary worker. So even if someone is a voluntary sex worker and someone is forced into prostitution, they should be treated with dignity. Victim should be provide relief and rehabilitation on the part of the state. For the case of voluntary sex worker, they should be also treated with dignity. They should not be harassed. No criminal charges should be levied against them. And rather, what should be they helped into, basically they should be helped or they should be given the chance whether they want the rehabilitation or not. Because the present law, the section 17 of the Immoral Traffic Prevention Act was treating the person who is a victim and person who is a voluntary sex worker as the same. But now the victim protection plan that the Supreme Court has come out using its power under Article 142 distinguishes between the same, provides for rehabilitation for the victims, and gives the chances of consent and dignity for the people who are voluntarily engaged in the prostitution. And we have also seen that prostitution per se is not criminalized as per the Immoral Trafficking Prevention Act. But if someone is being forced into prostitution, if prostitution is done in an organized manner, brothel keeping is done, or what we can call as if someone is what we call as if being forced from above or solicited into entering into prostitution, they will be penalized. Prostitution per se is not being penalized. So the court has created an important distinction: dignity as a criteria, consent as a criteria, rehabilitation for the victims, and such that the women are not treated into a binary. So this is an important thing that the Supreme Court has done, and we have also seen that why Supreme Court has done it and why Supreme Court has used Article 142, because the Parliament has not legislated a national law or national statute regarding the same until yet. So this was our first article. Now the second article relates with the Rajya Sabha, wherein it clearly says that Natarajan's Rajya Sabha papers are rejected, Congress cries foul, and they are basically trying to challenge it before what we called as the Supreme Court. So let us see what has happened in this case. Let us first understand about the case, and then we'll understand the constitutional as well as legal provisions regarding the same through Statutory Act of Representation of People Act. So what was this case about? Meenakshi Natarajan, a Congress leader and a MP, former MP, was the party's candidate for Rajya Sabha election from Madhya Pradesh. What has happened? Her candidature was rejected. Her candidature was rejected on 9 June by returning officer Arvind Sharma, following the objection raised by BJP leaders that her affidavit was incomplete. Why was the objection raised? That her affidavit was incomplete. Now, what is the Congress telling, and what are the prominent lawyers and who are also Congress members like that Abhishek Manu Singhvi saying? The dispute on what counts as a criminal case must be disclosed. The dispute turns on what counts as a criminal case. So what is the Congress saying? Congress argument advanced by Singhvi was that no criminal case in the eyes of law exists in this case. So the argument that a criminal case was pending before her and she has not disclosed it in the affidavit does not hold any ground. Why Abhishek Manu Singhvi was saying this? Abhishek Manu Singhvi was saying this for the reason that no criminal case in the eyes of the law exists, because it is a private complaint and no case comes into existence unless and until the magistrate takes the cognizance. And the magistrate has not taken the cognizance in this case up till yet. It has only issued a summon. So the main argument of the Congress side was that the candidature was wrongfully rejected, highlighting lacunae or the gaps in affidavits, wherein the Congress argument was that there is no criminal case that is pending before her, so she does not need to intimidate the Election Commission regarding the same, because only in the criminal cases where the courts have taken a cognizance, only in then you have to inform. So this was the prima facie argument about this case. Now let us understand about the provisions which can be asked in your prelims examination as well. What are the provisions? Let us see. What are the statutory provisions talking about? The statutory provisions comes from the Representation of People Act 1951. What is statutory provision talking about? Section 33A requires a candidate. Now this is important because Representation of People Act is also part of your mains syllabus, so it can be asked in your mains examination also. Representation of People Act, every year you will see in GS paper 2 one question is being asked. So what is section 33A of Representation of People Act? Section 33A requires a candidate to furnish information about pending criminal cases, specifically cases in which court has taken cognizance of an offence. So they have basically mentioned that in which court has taken a cognizance or cases of past conviction, so everything needs to be informed. This is the statutory provision that a person who wants to contest the election under section 33A, they have to inform what are the criminal cases pending against them, where the court have taken the cognizance or they were convicted in the past. First thing is that. Then Section 36 governs scrutiny of nomination, and under Section 36(2), under Section 36 Clause 2, the returning officer, which was done in this case, returning officer has the power to what we do, reject a nomination on enumerated grounds. The RO can reject the nomination on enumerated grounds, and Section 36(4) also mentions that RO shall not reject a nomination for a defect that is not substantial character. So Article 36, Section 36 of the Representation of People Act gives the power to the RO to reject the nomination on certain grounds, and it also says that RO shall not reject the nomination on the ground if the character is not substantial or if the reasons are not substantial. So this is what has been done. Now Congress has also approached the Supreme Court, and Supreme Court has done what? Supreme Court has rejected the application of Congress. And while rejecting the application of Congress, the Supreme Court has said that the Congress should go by appropriate channels. So next thing we have to understand is what is the legal remedies that is available regarding the same. The legal remedy is coming from the Constitution. The decisive doctrine is Article 329B of the Indian Constitution. It says that no election to Parliament or a state legislature shall be called in question except by an election petition. So the Supreme Court has said that there is a definitive way to go for the same, that is through an election petition. Let me tell you about election petition. Election petition comes from Article 329B that we have seen, and only through this way one can contest the election, one can basically contradict about any kind of violation done under elections through an election petition. This election petition will happen before the High Court, and that too after and once the elections are being conducted, not before that. So this election petition, the time frame of 100 days will be given, and that too after the elections are conducted, not before that. And if you have read High Court, you will have read about the original jurisdiction of the High Court, and you will read their MPs and MLAs election disputes. So election disputes can be raised where one of the criteria of raising election dispute is wrongful termination of candidature. So they can raise it, but it can be raised only after the elections is done within a time frame of 100 days. Let us see what is written. So it shall be questioned except an election petition presented to the authority and in the manner prescribed by law. Then Supreme Court has also said in various judgment, all electoral grievances including improper rejection of a nomination are channeled into post-poll election petition. Post-poll, they are clearly mentioning post-poll. And then courts will not intervene in the midstream. So in midstream that will not happen. In Jyoti Basu case, they have also said that right to contest is purely a statutory right and not a fundamental or common law right. That is why it cannot be appreciated or it cannot be encouraged under Article 32 because it is not a fundamental right also. So Natarajan cannot also go to the Supreme Court as a violation of writ, and that is why the Supreme Court has also rejected the application, seeing that it cannot be entertained under what we called as writ jurisdiction of Supreme Court under Article 32. Why? Because contesting election is not a fundamental right, it is a purely a statutory right coming from Jyoti Basu case. So now next thing that what it is telling about the actual remedy, then what is the actual remedy? That is, we can say that election petition under section 80 and 81 of the RB Act can be filed before the High Court within 45 days of the result, invoking section 100, improper rejection of a nomination specified on the grounds of declaring an election void. So the only way that is possible for her is to basically contest the election symbols, to contest basically what we called as the wrongful termination of or rejection of the letter that can be only done after the election and not between the election. So we have seen the constitutional provisions. Where does the remedy lie? The remedy will lie before the High Court, after the elections are conducted, not before that. And which are the statutory provisions? So we have seen section 33 and section 36. The section 36 gives the power to the RO. So RO was well within its power to reject the candidature on the basis of clause 36, clause 2 of the Representation of People Act. So we have seen all of it. And now we'll move to the last article, that is the political party symbols. And the article clearly mentions, can a political party use cockroach as a symbol? While the Cockroach Janata Party founder says that they do not want to come into active politics and they basically label themselves as a youth pressure group. But let us understand what is the constitution talking about the same. How does the constitution address this problem, or what is the constitution talking about the same? Now the election symbols are allocated to the party on the basis of an order that was issued in 1968. The election symbol Reservation and Allotment Order 1968. This order was issued by the Election Commission, and this order has to be read along with Article 324 that basically talks about election rules of 1961. So this order of 1968 is the sole order which specifies whether the election symbol or how the election symbol will be given to any political party that decide to contest the election. And this has to be read along with the rules of elections in 1961. Now let us see what it is saying, how the elections party symbols are allocated. The first condition is that of recognized national and state parties. Recognized party at national and state level. So these national and state level categories are given to them on the basis of their electoral performance. So on the basis of the electoral performance of a party in elections, they will be given national status and they will be given state party status. For these parties, they can choose the election symbols of their choice. So what is written? They get reserved symbol exclusively to them, lotus for BJP, hand for Congress. So they get exclusively their own symbol that they want. Second thing is that registered unrecognized parties. Registered unrecognized party, and third is that of independent candidate. Registered but unrecognized party. Unrecognized meaning thereby they are registered under the section Representation of People Act section 29A, but they have not been recognized in the sense that they have not shown their poll competence, or they have not been given the status of state or national party yet. So they are registered, yet they are unrecognized. And then we have independent candidates. These people have to pick from the symbols that will be given to them by the Election Commission. So Election Commission will give them the symbols, they have to pick from the same. Of course, they can do what? They can tell about a particular choice of election symbol from these lists. So there will be a list from which they have to choose. So they can choose from that, they can give their choice that we want this election symbol. So there will be a list maintained by Election Commission. If I am an independent candidate, I will go to the Election Commission, I will say that I want this. But this is my demand, this is my request to Election Commission that I want this symbol. It is up to the discretion of the Election Commission whether they want to give that symbol to me or not. So they do not have the choice of choosing their own symbol. They do not have the choice of reserved category for them. They have to choose from the list of the symbols that the Election Commission usually maintains. Now coming to the third part, which basically is whether cockroach can be used as a symbol or whether animals can be used as a symbol. So following has been seen that the election symbols cannot be used in the form of what we called as from 1990s, animal activist has argued that animals cannot be used as a symbol in political parties. BSP uses elephant as a symbol of their political party, but that was before the ban of 1990s. After that, elections, they are being seen that the political parties cannot use election symbols in the form of animals. So, animal cannot be chosen from the political parties. Recognized, unrecognized, recognized, registered but unrecognized political parties and independent candidates, they have to choose from a list of symbols that is maintained by the Election Commission. They can demand or they can request one election symbol, but Election Commission will be giving that symbol to them. It is their discretionary power, so they cannot say that we have not been given this election symbol. So this infographic basically also represents how the election commission basically gives the election symbols, where it has been categorized into 3 different categories, wherein the first is the recognized parties. They meet the electoral performance criteria. Their reserved symbol is reserved exclusively, that is given to them. Then second is that of what we call as registered but unrecognized parties, registered under section 29A of the Representation of People Act, but not recognized in the sense that they have not shown their political performance. They have registered with the election commission but have not met the performance criteria. So they have to choose from free symbols. They can request a choice but not assured of getting it. Then at the last, we have also independent candidates who have no party affiliation, contesting without any political parties, covered directly by 1968 order. Symbol, they are basically choose from the free symbol, and again they can request honored only if available. Request will not be honored. There is no guarantee that the election commission will give them the symbol of their request. If it is available, they will give it. If it is not available, they will not give it. So we have seen how the election symbols are being guaranteed. What are the rules of 1968 that governs, what is the order of 1968 that governs basically how this election symbols will be given to the political parties. And we have also seen that whether animal can be used as a political symbol or not. So these were the 3 prominent articles that appeared in the newspaper in the last 1 week. I hope you have the understanding of the same. Next week we'll meet at the same time. We'll understand different articles coming from Polity as well as IR, try to understand them, relate them with the mains as well as pre-prospective. Thank you.